begin when ready.
Habeas corpus addresses the rights of the literal body of a person, and in doing so, it also addresses the body of justice required in the U.S. Constitution. Thus, habeas corpus becomes essential to the principle of limited government as it restricts government intervention in the lives of individuals and defends against tyranny.
Habeas corpus protects against illegal and indefinite imprisonment. The translation from Latin is to produce the body. Thus, a person who's detained has the right to file for a writ against their imprisonment, resulting in a judge ruling whether that imprisonment is lawful.
Sir William Blackstone argued that while taking life or property without a trial is an act of despotism, confinement of the person by secretly hurrying him to jail where sufferings are unknown or forgotten is a more dangerous engine of arbitrary government. Furthermore, in Federalist 84, Hamilton classifies habeas corpus as one of the greatest securities of liberty that any constitution can contain.
So, habeas corpus is an essential protection of personal liberty, but also a fundamental element of limited government. It is an essential check against a tyrannical executive, which prevents him from removing political enemies through imprisonment or detaining people without just reason or without providing due process of the law.
The Habeas Corpus Act of 1679 and English common law are the foundation for habeas corpus in the United States. After separation with Great Britain, the right was enumerated in the Constitution in Article 1, Section 9, and continued to evolve through congressional and court action.
The Judiciary Act of 1789 empowered federal judges to issue writs of habeas for prisoners in federal court, but the evolution of the writs focused on federal power over the states. Then the Habeas Corpus Act of 1867 extended the federal authority to state prisoners and for post-convictions. Between 1879 and 1915, the court limited habeas corpus for state prisoners, requiring that all possible remedies be made in the state's courts before involving a federal court.
Then 1953 Brown v. Allen held that federal district courts could review state rulings, even if the Supreme Court chose not to hear the appeal, thus expanding the federal supervisory power. The 1996 Anti-Terrorism and Effective Death Penalty Act limits a federal court's use of habeas corpus to when a state court's decision is contrary to what the Supreme Court has determined is clearly established federal law.
While the federal government has expanded their power over state habeas cases, all 50 states protect habeas corpus in state courts. The Arizona Constitution states in Article 1, Section 14, that habeas corpus shall not be suspended by the authorities of the state.
There are several areas of concern regarding the burden habeas corpus places on the government. First, enemy combatants, especially in times of crisis. 2004 Hamdi v. Rumsfeld held that within the protections of due process, enemy combatants had the right to contest their detention in court. The opinion cited the Fourth Circuit Court's explanation that the purpose of suspending habeas corpus for enemy combatants is to keep them from rejoining the enemy, thus identifying the burden on the government.
Next, asylum seekers. 2020 Department of Homeland Security vs. Tharasegam explains if courts must review credible fear claims, then the eyes of immigration officials and an immigration judge do not beat the low bar for such claims. Expedited removal would augment the burdens on that system. Sotomayor's dissent claims that the decision handcuffs the judiciary's ability to safeguard individual liberty. The struggle to find balance between preserving personal liberties and protecting the country from enemies or maintaining an immigration system is necessary, despite the burden it places on the government.
The mandate for establishing justice is written into the first lines of our U.S. Constitution. As such, habeas corpus reveals itself to be an essential component for the citizens of the United States, as well as the ideals of our founders. That is, ensuring liberty and justice for the entire body.
Great. Thank you very much, everyone. Let's start with a historic example. A very famous example of the suspension of habeas corpus was in the run-up to the Civil War and Abraham Lincoln suspending the writ. Could you guys evaluate Lincoln's actions and maybe give an opinion one way or the other if it was justified?
Although it seems a reasonable use of a habeas corpus considering that it is a civil war and the right side won the war, in ex parte merriment and Merrigan federal courts, Justice Roger Taney argues that Lincoln never had the power to suspend the writ of habeas corpus. It was never an executive power. So although I agree with Lincoln's and that it was a good intuitive use of the suspension of the writ of habeas corpus, and even Congress agreed with it later, the executive never should have the power to do it in the first place.
The key word, though, is that Congress did it later. It needed to be done now. In Federalist, well, Alexander Hamilton stated that an executive needs to be able to do what needs to be done right now. It needs to be in the sole power of the executive so it can be done quickly and efficiently. So I believe that Abraham Lincoln suspending habeas corpus was the efficient thing to do at the time because Congress was not in session.
All right.
Thank you.
Very good. This is more kind of seeking your opinion and your critical thinking around it. So you referenced a couple of the court rulings more recently with enemy combatants and the war on terror. Do you just elaborate a little bit around the court's decisions and whether you agree with the court, with the way it has headed based on court rulings in that regard around enemy combatants?
I do agree with the current court rulings that is allowing enemy combatants to seek habeas corpus, because I think that habeas corpus is in our Constitution and the Constitution is the law of our land. And thus anybody under our jurisdiction should be subject to the entirety of our law. An opinion also found in the dissenting opinion in 1950, Johnson v. Eisentrager, where Justice Black said that we should seek equal liberty for all people, not just the citizens of the United States.
In addition to Hannah, I also agree with the Supreme Court's ruling. Two Supreme Court cases I agree with is Rasul v. Bush, which essentially extended the writ of habeas corpus to our territory, specifically Guantanamo Bay, allowing 600 different individuals who are simply just suspected of terrorism to apply for the writ of habeas corpus. And also Bush v. Median of 2008, which said that the 2006 Military Commissions Act was unconstitutional for its vagueness of the Enemy Combatant Act, was another Supreme Court decision that I agree with, essentially allowing terrorists who are at least suspected for the acts to get the writ of habeas corpus.
Thank you very much.
So let's shift to another historical time, the internment of Japanese Americans. Evaluate that. Was that an appropriate and legalistic use of that power?
In Korematsu v. United States, they tried to overturn the decision of internment into Japanese camps. I believe that it should not have happened. Only a few of the Japanese were found to be spies within the camps, and only a few should have been punished, not all Japanese Americans within America.
Yeah, with the Organic Act being passed in 1900 and later on December 7th in 1941, the writ of habeas corpus being suspended, I completely agree with Tyler. Although it was argued a military necessity because yes, Pearl Harbor was being bombed, we shouldn't have interned every single Japanese American that we could find, especially we didn't have most internment camps and most individuals in these camps weren't actually had any evidence or credible evidence against them. So it made no sense just to suspend and put everyone in these internment camps if you have no evidence against them.
Maybe I'll try to, we'll have this conversation be a little bit broader. We've been talking about habeas corpus, of course, in the question. Are there other civil liberties or constitutional rights that come to mind that have been set aside or suspended in times of crisis? And was it justified in those instances?
Part of the suspension of habeas corpus is also just the suspension of a due process where people no longer get their initial appearance at court. Sometimes they don't even get to hear the real reason why they're being detained. But in this case, I do not agree with that. Due process is written into the Constitution in the Bill of Rights amendment, the Fifth Amendment. And so as such, it should always be granted to the people.
In Arizona, under the COVID-19 protocols, we are unable to we haven't fully suspended habeas corpus and due process. We've had to postpone it because we only have 9 out of 40 or 50 justices that can actually attend a courtroom with a jury and still keep COVID protocol. And in this case, the people that are in jail will have to keep an extended time up to a year to 2 years before their case can be heard.
Let's go back to enemy combatants and Guantanamo Bay. You rightly expressed the rulings of the court in several situations, but what's actually happened? Have we had any trials of these people in the United States?
There have been a few of them who have been brought over to the United States for trial, but most of them have just been consistently detained. And we actually see recently Colonel Lawrence Wilkinson, backed by General Colin Powell, actually, they were part of the Bush administration. And they said that actually like President Bush and the vice president and the Secretary of Defense all actually knew that the majority of the people in Guantanamo Bay were innocent, but still just detained them there.
Adding to the idea, we see that many of them are innocent. In the Guantanamo Bay files leak of 2011 and multiple leaks saved by The Guardian, we see that most of these individuals were ended up being innocent. Of the original 775, we found that only 40 of them remain because most of them are proven innocent. And with these 40 individuals, we don't actually have any well, there is no subsequent link for all 40 of these individuals to be proven terrorists. So we find that already 5% only we couldn't find some sort of evidence for that. And even then we aren't able to prove that any of them are actually terrorists while they're still just being detained in Guantanamo Bay.
Is that okay?
No, it is not okay. In the case of the lawyer and system called Reprieve, in 2007, they had a case with a child who had been put into prison at age 14, but due to somehow gaining his age, they said that he was 17 when he was put into the Guantanamo Bay prison. And now, as they released him, and they had no credible evidence, and that was just wrong as a total, due to them just being handed over by the Pakistani military with no evidence against him. He was held in the prison for 7 years until Reprieve could find a way to release him.
So in the minute we have left, in your research on, and which is apparent on this question, what did you discern around trying people in absentia or not being present, and its relationship to habeas corpus? And so having a trial where the defendant's not actually there, are you aware where that's permissible? Or
in Uzbekistan, as of right now, they have the process where people are put into prison and then they're tortured as well. And then when their court date comes up, they're not even sometimes there in front of the judge. And even if they are there, the judge will just stamp their case and send them to prison. And even when they can fight the charges, the judge won't even listen to the charges that they are trying to.
Were you finished? Because you certainly couldn't finish your thought. It sounded like you were close to done.
I was close to done, but
okay.
I was say that true habeas corpus hadn't been achieved.
Okay, awesome. Good job, everybody.
Nicely.
Great job, Arizona. I'm looking over the notes that I didn't have time to write down everything. You guys were throwing so much so fast at us, which is good. I was certainly impressed by the breadth of evidence in your opening remarks. We go Blackstone's commentary, and then we're talking to the present immigration debate. So we're looking at the full scope of the picture here. And I think that the understanding of the question, it was evident, and you answered all of the parts that were brought up. And I appreciate the COVID answer too. That's a new ace up my sleeve for future rounds here. So thank you for giving me that question to bring up later. Yeah, I'll stop there. This was a great job, very impressive.
Yeah, I concur. That was most impressive, Arizona. You clearly answered the questions, and in your essay, I was really impressed. Your ability to pull in seemingly at ease, it probably, that's the way you make it appear, which is commendable. Case citations that was more in a discussion that you obviously were aware of, but you hadn't, you didn't know the question being asked, so you weren't able to memorize that you had that right there, but you had it at your fingertips. I actually, though it can be uncomfortable, I think, for the participants, your slight pauses and then coming in with a very thorough response was also impressive, I thought. But you each participated exceedingly well. You played off of one another in a positive way, and would give countering kind of critical thinking responses to the questions. So nicely done. We wish you the best going forward.
Yeah, I can't more strongly concur with my colleagues. That was an exceptional breadth and depth of knowledge. I also commend you for your ability to give us the reasons for your thoughts, and that's so important. Throwing out a court case, everyone does that, but then you actually told us exactly how it connected to the principle and the idea you were trying to express. And that's argumentation at its highest level. I commend you for that. Keep struggling with this, because you have on one hand this very, I mean, I love habeas corpus and I love limited government. It's fantastic, but it's on paper, right? And so as I think it was it Franklin? It's a parchment barrier. That piece of paper and all those beautiful ideas are very tenuous, and we're counting on you three and amongst your peers to carry us forward and make sure that those words actually mean something. That's why in the end I'm like, is that okay? And I want somebody to get mad, right? Because damn it, that's our Constitution, and I sense that that's where you're at. And so I commend you all, and I look forward to being in your future. So good luck to you.
Thank you,
All
guys.
the best. Good luck.
Way to go.